Assalamualaikum sir, I'm Fatina Hana binti Yusuf, a student from AM 1103F.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shanis Maira binti Cik Muhammad Sufian. I am from class 3F.
Assalamualaikum sir, my name is Nur Mazira Shazina binti Muhammad from AM 1103F.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Amali Izzati binti Muhammad Nasir.
In this video, I will explain the introduction about the independence of judiciary in Malaysia. For that, I will explain a little bit about judiciary body. Judiciary body is a third branch of the government in Malaysia. The judiciary is responsible to safeguarding the supremacy of the constitution, and it's also carry out the duties in court where their task is to interpret the federal constitution and state constitution. However, judiciary branch has a relationship with Malaysian federal constitution. In constitution, parliament has power to make a law, but the court also has power to repeal the law made by parliament if it is unconstitutional. There are two categories of system in judiciary. Firstly, superior court. In superior court have federal court, court of appeal, and high court. Secondly, subordinate courts, which are session court, magistrate court, and magistrate of children courts. Besides, judiciary body has given an independence by the Malaysian Federal Constitution, where the other branch like executive and legislative cannot control in judiciary administration and legal. For example, the executive cannot intervene when the judiciary want to make a decision. However, the task of judiciary is only to interpret the law, so they cannot be responsible about the problem involving rules and law. Then, the judge must have integrity and dignity and independence of mind to make sure they fulfill their task wisely. From the explanation, we agree that the independence of judiciary is true. But I'm curious, what is the factor to ensure independence of judiciary in Malaysia as stated in the Malaysian Federal Constitution?
I'm going to present about appointment of judge in independence of judiciary.
There are three methods of appointment of judge. Firstly is election by legislature. Under this method, there is a wide range of different types for this appointment, which are appointment to constitutional or supreme courts, typically involve either a representative mechanism or a cooperative model. The other system allow a single institution, either parliament or executive, to make appointment. The representative system is one of the several political institutions that will select a certain percentage in the court. The motive of representative system are designed to assure a mix of different types, including professional and political background on the court. Next is cooperative system. Under this system, there are two or more institutions are needed to cooperate in terms of appointing the judge. For example, is the Supreme or Constitutional Court Justice in the United States must be nominated by the President and approved by a House of the Legislature by a majority vote. However, under this system, raise the deadlock, since appointment require the agreement of a different institution to go forward. Then in some system, a single political institution dominates. For example, is German Constitutional Court is effectively appointed by the Parliament, with each house of the legislature appointing an equal number of members to the Constitutional Court. Under this method, there is also judges are appointed by a government minister, typically the Minister of Justice or Attorney General.
This method is not common used to appoint the judge because it shows that this method leans forward accountability rather than independence. Other than that, this is not good as the judges are appointed based on the political consideration. Secondly is election by people. In American, each state has its state judiciary, with each American state has its own state judiciary with their own system of appointments. There are two types of basic dimension which this system differ. First is whether the election is partisan or not, and whether elections are used for initial appointment or only for retention. The partisan election allow judges to make a party ticket and then appear as Republican and Democrats. However, the non-partisan election do not allow party affiliation. Then the public will decide whether to retain the judge or not based on their judicial record, and the judge will then be subject to the periodic re-elections. To conclude, the election of the judge is not highly recommended. It is because the judge then will be highly politicized. Then, in electing judge does allow for some accountability and was originally designed for United States because want to ensure that judges are not appointed by elite politicians but by the public of the state. Lastly is appointment by the executive. The appointment of the judge by the executive is the most common method in Malaysia. The appointment of the Chief Justice is governed based on the Article 122B of the Constitution of Malaysia. The Judicial Appointment Commission was set up under the Judicial Appointment Commission Act 2009 to assist the Prime Minister in advising the Yang di-Pertuan Agong on the appointment of the judge in Malaysia. The after that, the appointment of the judge to the Superior Court and Judicial Commission, including the appointment of the Chief Justice, the President of the Court of Appeal, and the Chief Judge of the two High Court is by the YDPA based on the advice of the Prime Minister. In summary, this is the best method to use for the appointment of the judge in the independence of the judiciary. However, simple nomination of the executive is not adequate, which is the judge should be appointed based on the merits. In Malaysia, the candidate must have quality like integrity, competency, experience, impartiality, fair and good moral character, and physical and mental health to ensure the judge that have been appointed can handle the judiciary in Malaysia wisely.
In my video, I will give my presentation about the factors of independent judiciary in Malaysia. My first factors is about the judicial tenure. Judicial tenure is in order for the judicial power to be exercised in a manner compatible with constitutional government. It means it is a self-evident proposition that the sentinels of this power should be guaranteed security of tenure. When the judicial power is exercised against the state, there should be no possibility of retaliation against the judge concerned. However, the citizen who is challenged and abuse of power by the state, they must be assured that the adjudication is effected in an impartial and independent manner. The public's confidence in the impartiality and independence of the judge is secured by the ensuring that judge cannot simply be removed according to the whims and fancies of the government of the cities. Government of the day. Next, Constitution government requires entrenched protection of judge by providing them with security of tenure, which is manifested in different forms. In Malaysia, the removal mechanism is abounded in Art 125, the Constitution. The Merdeka Constitution adopted the tribunal removal system, contrary to the recommendation of the Rate Constitution Commission, which had recommended the parliamentary removal system. The steps required by Art 125 of the Constitution. The first step is there is a representation made to the King by the Prime Minister or by the Chief Justice after consulting the Prime Minister. The second step is a tribunal is appointed by the King and the representation is referred to it. And the last step is the tribunal makes a recommendation and the King may on the recommendation remove the judge. Next factor is non-interference of the executive. Constitutional government embodies the nation of the rule of law. There are certain fundamental requirements to ensure the existence of that nation. According to Professor Joseph Ras, they include the independence of the judiciary must be guaranteed. Next, the principle of natural justice must be observed if the law is too able to guide action. The last one is the courts should have no power to examine the action of the other branches of the government in order to determine whether they conform to the law. The exercise of judicial power in a country founded upon the principle of liberty and justice. A number of provisions were inserted by the farmer into the constitution to maintain judicial independence. Removal of judge can only be effected following a recommendation by a tribunal that a judge should be removed on the ground of a breach of the code of ethics or on the ground of inability. Subject to the removal procedures, judge hold office till the age of 66 only. Judicial remuneration cannot be varied to the disadvantages of judge during his or her term of office. Overall, to carry out its role as a constitutional bulwark effectively, the judiciary must be able to sustain public confidence in its impartiality. As Lord Taylor of Gosford said, public confidence in the fairness of the justice system depends crucially on the judge being believed to be impartial, free from bias and from external influence. That confidence is displayed when a losing party accepts a decision of a judicial officer. There is ready acceptance when a decision is rendered by a judicial officer who has obviously conducted a hearing fairly, found the facts honestly, applied the principle of the law genuinely believed to apply, and give a reason for decision which show that this process follows.
I will further the explanation about the factors of promotion and salaries to ensure independence of judiciary. Who appoints this judge of authority and how? This appointment procedures can be unduly influenced by the political or personal consideration of the appointing authorities. To avoid this risk, it is of paramount importance to guarantee transparent, objective, and non-discriminatory procedures. This also applies to the election procedures in the system where judges are elected. It is generally agreed at international level that judicial appointments should be made on merits based on objective criteria pre-established by law or competent authorities, and that political consideration should be inadmissible. Persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualification. The same principles apply to the judicial promotions, which should be based on objective factors in the particular of ability, integrity, and experience. In most civil service, judiciary judges are recruited by means of public competitions based on written and oral exams, in which the theoretical knowledge of various branches of the law is verified. As a rule, the participants in those competitions are young law graduates without professional experience or with a limited professional experience, although the years of experience vary among the countries. Under the professional system, judges are recruited a specific position in a specific court without any formal prospect of a future career or transfer from one court to another. Therefore, there are no formal provision for advancements, although higher-ranking judges often exert some influence in both the initial appointment process and the promotion of judges from the lower ranks. Since the promotions are not widespread, on the whole, there are much weaker internal controls over the judge by their higher-ranking college. The factors of salaries and pension of judges are important elements to be considered for the protection of judicial independence. It is generally accepted that salaries and pensions must be established by law and be adequate and commensurate with the status, dignity, and responsibilities of judicial office. Salaries is a condition of service, and pension of judge should not be altered to their disadvantage after appointment. To this end, legislative or executive powers that may affect judge in their office, their remuneration, conditions of service, or their resources shall not be used with the object or consequences of treating or bringing pressure upon the particular judge of judge. For example, Canada in 1990s general economic difficulties caused several Canadian provinces to reduce the salaries of provincial court judges. Some accuse a person and one provincial judge association argued that this reduction violated the constitutional guarantee of judicial independence. The Canadian Supreme Court was called upon to establish a framework for decision-making on the remuneration of provincial court judges, consistent with their preserving their financial securities. The court has made three key of finding. First, judicial salaries can be reduced, increased, or frozen, but only with recourse to an independent, effective, and objective commission. Second, there are to be no negotiations of judicial remuneration between the judiciary and the executive or legislature. This prohibition is based on the view that such negotiations are inherently political and that they would put in the courts in a conflict of interest because the Crown is often a party before them. Lastly, judicial salaries may not fall below a minimum level, while the court did not set a minimum. It explained that if salaries are too low, there is a risk, whether real or perceived, that judge will adjudicate in a certain way in order to secure higher salaries from the executive or legislature, or be manipulated by offers of benefits from litigants.
As a conclusion, the judicial is an important role in the Constitution because they are concerned about the administration of justice. So there are several factors in make sure the independence of judiciary in Malaysia. First is appointment of the judge, where the election of the judge will select by the legislative, the people, and the executive. The person who wanna be a judge must good in physical, mental, and heart. Then judicial tenure, which means the length of judicial service. Non-interfere of executive also one of the factor. The judge must free control by the executive. Besides, in promotion, the minister and the committee of the judge will recommend the judge name who are eligible for the promotion. Lastly, salaries. The judge will paid in high rank to make sure they are not involved with the corruption. I believe that an independence of judiciary is the crown of constitution democracy. That's all from us.